All right, we're going to get started. It's 5 after. I was furiously packing. I'm leaving for California tomorrow. And it is recording.
Trust me, you will hate it. I was just there last week.
This Agono, Aleo Viejo, or however the hell you, whatever.
Aliso Viejo. Yes,
Yeah, that.
we were back there getting Gene out of there from Wildemar. So I forgot how much I hated out there.
Right, so we're going to call to order at 7:05 Mountain Time. And well, instead of packing, I could have, I am so scattered right now. I could have been pulling up okay. It's making me sign back in. One moment. And I have to find my password because it's in the secretary account and that password's not saved on my computer. Give me 1 second. And that's because I refuse to do separate Chrome profiles. I hate that. I hate that. Hate it. One moment and I'll have the agenda up. All right, I will share my screen. You should be seeing my screen now. I can't see anything in Zoom. Zoom's gotten really terrible with that. And I think it's just when you have multiple screens. So, one moment. If, Madam Secretary, could you take attendance, please? You're on mute.
Darrellwood here. Rocco?
Present.
Sizelski?
I am here.
All right. Latham?
Here.
Harlos?
Present.
Martin?
Present.
Moulton?
Present.
Rowlett?
Here.
Rufo?
I'm going to shoot him a text, but he's not here right at the moment.
Okay. Seebeck?
Yep.
Okay.
Rufo might be traveling. A lot of the LNC's traveling today.
Could be. Of the alternates, Tommaso? Roberson?
Here.
Okay. Deal? Roots? Logan?
Here.
Dean Rogers?
Here.
All right. If Mr. Rufo isn't here, Mr. Roberson would move into his spot.
And just an FYI, he said he will be here in about 5 minutes. His child has a hockey practice now on Thursdays, and that's what's making him late. But anyway.
Okay.
So now is opportunity for public comment. I know there's a few members of the public here. And also, you all know the shtick by now. That also applies to committee members. If you have something that might not necessarily be perfectly on the agenda, I do have something that I'll get in line for, but I wanted to see if there was anyone else. Okay, I see Mr. Jacobs, then Mr. Latham.
Mr. Latham first, please.
Mr. Latham?
Yeah, just to give a heads up, there was a discussion with recent delegate allocations that our bylaws do not have a mechanism if, for example, an affiliate thought that they were undercounted, how they would go about appealing that decision other than bring it up at convention, or I guess rely upon a national committee motion to address it. So I'm just working on a proposed bylaw amendment to address that, and I'm just, the working thesis is that the national committee just has to ratify that secretaries count. And just
I have to
okay.
tell you,
This is my time. Is this
Okay.
my time?
I wanted to give you some info that would help.
Okay, can you give my info after I've completed my
Yeah,
thought,
I
or do you
certainly
think it's
can.
important to?
I think it's important
Why don't-
because it might.
Okay, why don't you do it? Maybe I will stand corrected.
No, you're correct. There isn't a process, but I can tell you, I think that belongs in. Let me put it this way: we're going to probably pass a policy manual amendment addressing it. I've been in contact with Mr. Short and requiring an LNC ratification. So I think this is going to be addressed in the policy manual.
Okay, well, and that's all well and good, but I guess my point is policy manuals can be easily amended and changed, and then the affiliate doesn't really have a straightforward remedy. So, but yeah, the idea is that the national committee would just ratify that number. And what that does is it creates a potentially reviewable LNC action that if a member or affiliate wanted to appeal that to the judicial committee, they could. So anyway, just watch for that on the list.
Thank you, Mr. Jacobs.
Thank you, Madam Chair. Can you hear me?
Yes.
Very good. I just wanted to point out that there is a principle called the exhaustion of remedies, that when something would not become ripe for appeal or for adjudication until after all internal remedies are exhausted. That might have some bearing in some of your discussions tonight. I'm just noting that. Thank you.
Thank you, Mr. Jacobs. I'll let you go ahead of me, Mr. Latham.
Well, speaking of exhaustion of remedies, I'm just aware of a recent legal opinion that came down, and I forgot where. It might even be in my own state, but it might be federal. And they decided to say that an appellant doesn't have to exhaust administrative remedies because they kind of recognized that can be so, involved that you kind of lose the whole your rights by taking all the time you needed to do to go navigate this Rube Goldberg process, and so there is kind of some revisiting of that I guess concept, that you can just kind of take a more direct route and bypass those appeals. So just another food for thought, but I'm well familiar with the concept of exhausting remedies, and I think that's the default. If there's other processes in place, you ought to do those first. But sometimes I guess they can become so unwieldy that it's appropriate to allow a more direct route.
The way I understood it, Mr. Latham, and you can let me know if you agree, I think it's a rebuttable presumption. I do think there's a presumption that you need to exhaust your remedies, but it's not an unrebuttable presumption. It's a rebuttable presumption.
And that may well be, and then the other maddening probably twist of this is that it probably depends on what statute you're dealing with, and what where this administrative remedy or where appeals need to be exhausted. So those aren't easy answers.
I think it becomes more easy though in the context of bylaws, which is what we're dealing with. Because like if you're in a voluntary contract and you've agreed to say, well, binding arbitration clauses are binding. I'm not saying that that's what's in here, but if something that you agreed to that isn't adhesion, that you didn't have to agree to, such as voluntarily joining a political party, I tend to think in a bylaws context that if there's remedies within the bylaws, that the court is going to uphold that. But if you're talking about weird, like government administrative agencies or something like that, I think that's a rebuttable presumption. But I think in a contract, it's probably a bit stronger. That's my sense of the law on this. Okay. And for those who aren't familiar with the term, I mean, Rob knows it, an adhesion contract, a lot of people would consider where you can't negotiate at all, or you're kind of forced into it, like in ISO insurance policies, where all the insurers are using the same policy and you can't really like negotiate some of these standard terms. There are some, because I work in insurance law, where that sometimes insurance policies are considered adhesion contracts. That's a whole other thing, but that's an example that most people can relate to.
I've heard some attorneys joke that marriage is such a contract.
Yeah. There are days I might agree to that. Not with the current husband. Wayne is wonderful, but I'm thinking in the past. Okay, so the comment I had to have, this is not confidential or anything like that. It will be put on the website soon. An announcement will come out. As everyone knows, with the convention, we have convention standing rules, so we have to do things in a certain order, but a lot of other things are left up to the discretion of the Convention Oversight Committee or the LNC. There's been somewhat concern and some drama and some complaints over adding those extra 2 hours on Monday. We have the facility for all day Monday, but the Convention Oversight Committee has voted to schedule adjournment sine die for Sunday. Too many people are like, yeah, it must be nice to have a job where you can be off Friday and Monday. We were going to travel on Monday because it's already a holiday. So knowing we have the facility, the delegates can move to amend with a 2/3 vote at any time during the weekend to add more time, but it's not going to automatically be on there. The Convention Oversight Committee has struck the Monday schedule and put everything that was on Monday, which was just other business, something really vague, and resolutions. That's going to be directly after President and Vice President. Of course, the convention can vote, because we do have the room, can vote to extend. But in case that affects anyone's travel plans, if Monday was proving to be a huge burden, just make sure you're there on Sunday. And if someone tries to extend it, vote it down. Or alternatively, hey, your buddy's going to be there till Tuesday and you want to go to Monday, then vote it up. I'm just giving you guys some information that adjournment sine die is now set for Sunday. Mr. Seebeck, then Mr. Bracco.
And be advised that platform committee is going to try to get more time than what we have, because the 90 minutes that we've been allocated on that Saturday, well, frankly, it's not enough. And the argument about does it a speed round in Reno doesn't hold water either, because that's just because of the way Reno just happened to happen with all the goofy stuff with the AV crews. So there might be some attempts to try to extend on Monday for that purpose as well.
Well, we just got to do all of our elections quickly, and then there'll be extra time. Let's just put it that way. And maybe we will. Maybe we will. I mean, I'm recruiting a shit ton of tellers because I want the LNC rounds to go fast. And if
as long as we can get California and Virginia to behave themselves.
Yeah, we will. The Convention Oversight Committee has been working on a lot of things. So if LNC, I'm sorry, this kind of is somewhat relevant, but then we're going to stop on platform stuff because just FYI, if LNC elections finish early, then the the platform committee report can start early and go later, but obviously you can't count on that. So if Mr. Bracco.
I guess this sort of parliamentary inquiry, but it might be more relevant for the national chair at the convention. But if the motion to extend is prior to the adoption of the agenda vote, Does it take 2/3? Because I mean, the timing isn't specified in Rule 1, only the order.
I don't know. That would be up to the convention chair.
Okay, just wondering.
I'm going to tell you, this is relevant to bylaws because we do have a proposal for this. And y'all can tell me shut up if you don't want to. That part of the consideration that also is this is going to be a very contentious convention. And I advise the Convention Oversight Committee that they should, if they want to add a day in the future, to add it at the beginning and not at the end. Because what happens is people go home and then you could have a severely unrepresentative majority that barely meets quorum and deletes the platform or something. I'm just giving a Portland massacre thing. And that's kind of what happened in Oregon. It wasn't on the last day, but it was 300 people that were at that convention that deleted the platform. If you add on to a Monday, you could have 300 people delete the bylaws, delete the platform, do whatever they want, really, as long as it's still quorum. And we have a legal issue with quorum. I disagree with Mr. Brown and agree with Ms. Mattson. I don't know what the party chair thinks, but I don't think we're allowed to check out people at our convention. We've done that for years. It's our custom. I think it's absolutely wrong. And I think there could be a legal lawsuit over it. If somebody did something crazy on Monday and went because people checked out, it was decided there was quorum, because I do not believe that's what our bylaws say. And I know Richard Brown has a different interpretation, but Ms. Mattson has been screaming about this for years. And I can tell you, if somebody tries to do a checkout procedure, I'm raising a point of order at this convention, unless we make it clear there is a bylaws proposal for it. But people need to consider that there's going to be very few people there on Monday. And if the delegates want to delete the platform or do anything else crazy, pass some weird ass resolution, let's do it when there is actually the majority of delegates there, when you have 600, 700, 800 people there, so that it's the legitimacy of it isn't questioned. We are already a very fractured party. Setting things up to be questioned for legitimacy purpose because there isn't that many people there could potentially torch the party, because states are already on edge. So all of that went into consideration. If the delegates, when we have 700 people there or 800, whatever it is, to elect our presidential candidate, if they want to extend the agenda, that means most of them want to, and it grants it legitimacy. Let the delegates legitimize that if they want to. So that's kind of the thought process. So people thinking of Monday things, I'm not voting to have anything on Monday. I don't want 300, 400 people deciding stuff for the party. I think it will fracture us. That's just my personal opinion. The delegates are going to do what they're, and I'm assuming I'll even be a delegate. I don't know. But the delegates are going to do what they're delegates. So let's just get LNC elections done early so we can have more time for platform on Saturday. Okay. Town hall. If we want to do another one, do we want to think about some January dates now? Do you want to put that in a future agenda to consider? You want to talk about that over email? Mr. Bracco?
Would January be the best time? I guess, is the intention of this town hall to be, we've adopted the proposals that we're going to adopt, and maybe the report has to be finalized. Maybe you combine a few proposals, whatever. But that's kind of, I guess we have to limit to pass that special rule to make it official. But is the intention to finish with proposals before the town hall?
We were going to be done with proposals at the end of December. So yes, this was to have all of our proposals up for discussion, even if we haven't combined or dropped any. So I wanted to have it immediately, as close to immediately as after we kind of had the gentleman's agreement that we were going to be done. Thoughts? Mr. Seebeck, excuse me, you had your hand raised?
Yeah, you answered my question before I could ask it.
Okay, well, I don't, iPhone update, I hate it, just by the way. It like defaults to Siri, and I don't like Siri. Like, go away, Siri. 1 second. So, where is our schedule right now? We're meeting on the 14th. We're meeting on the 28th. What do you all think about January 18th for a town hall? And why I put it on the 18th rather than, no, not the 18th, excuse me, January 11th. If there's no objection to that, I'm going to work with the LNC on getting that, an email out for that. Okay. January 11th it is. I'm sorry?
I guess looking at the proposal list, I think, let's see how many are left. I think it's a lot. I don't know that, like, that's only 2 meetings between, well, I guess the rest of this one, plus 2 meetings in December. I think that's aggressive if the goal is to have all these proposals voted on one way or the other, all the way through SS or whatever the last one ends up being.
Oh, we discussed this a couple weeks ago. I guess we'll see where we go, but unless somebody's going to move to override me, I'm setting the next town hall for January 11th.
No, just commenting.
Okay. So January, unless there's some kind of problem with, I don't think there'll be a problem with the LNC. It's a matter of getting them to get emails out to, I know they have a very aggressive fundraising schedule coming up. All right. As far as, I mean, it's 1 day before December. We had said the first meeting in December, but with it December being tomorrow, did anyone want to move that special rule of order to be able to limit debate? Would require a 2/3 vote to enact it. Otherwise, that's not in place. I'd already said I'm not moving it. It would have to be a committee member. Mr. Bracco?
What exactly is the language of this?
It would be to adopt, because we have authority from our appointing body, to adopt a special rule of order allowing motions to limit debate and limit or end debate.
So this would not be a motion to stop new proposals. This
No.
would be
It
on
means you
an
could call the
individual proposal.
question.
Yeah, okay.
That all it
Okay.
does is allow people to call the question. Or maybe
Okay.
if you all wanted me to put time limits on things on the next agenda, like it would allow us to, I'm not planning on doing that unless there's a motion from the committee, but it would allow us to make those kinds of motions. Mr. Bracco?
If this is not voted on this meeting, could it be brought up in a future meeting?
Yes.
Okay.
So does anyone wish to make a motion to adopt that special rule of order? Mr. Sazalski?
Yeah, I'll go ahead and make the motion.
Okay, Mr. Rufo is entering. So were you fine with my wording for the secretary, which was move to adopt a special rule of order permitting motions to limit or end debate?
Yep.
Okay, I'm going to ask, is there any objection to that motion? Okay, seeing none, that special rule of order is in effect. It'd be then just like any other board. You would have to make that motion. It would have to pass by 2/3. Ms. Arrowood had put up the minutes from the previous meeting. Are there any corrections to those minutes? He's seeing none. Those are passed. So now we're back to the proposal from Mr. Rolette, which was on resolving affiliate disputes. I had put alternative language in the email group. There was some limited participation with it. I'm going to see if I stuck it in this proposal here. This is the old proposal. I didn't stick it in here because I was waiting to see if there was more. So I'm going to stop my share for a moment so I could go grab it because it's in my secretary email. But while I'm doing that, Mr. Rolette, if you'd like to speak.
When you get it up there, I'm gonna move the revised proposal, but with Bracco's 2 main amendments to it, but not his third, if that's appropriate.
Yeah, let me get that up here. I don't remember what his. Why did. Okay. This ended up weird on mine. So I'm going to get this on the screen and then you'll just have to let me know what those changes were. Let me get my screen share because I don't know which two you're talking about. So you're going to, before you formally move this, let me know how you would like it changed. And that will be the initial motion. So it's on the screen now.
Sure. Let me open up that email there. Okay, let's see if I can find it. Okay. It is okay, back to the other screen. Sorry, everybody. Okay, it's what you have up there, except also after the word shall, where it lists chair, vice chair, secretary, treasurer, or Libertarian National Committee, comma, and then upon a signed petition of at least 10 sustaining members of the party residing in the appropriate state. That's Bracco's first amendment. And I don't think he broke it up like this, but, and then second, a little farther down.
Okay, that went too fast. Upon a
I'm sorry.
petition of at least 10 sustaining members.
Of the party residing in the appropriate state.
Okay.
And then a couple sentences down, it says, if the affiliate has its own judicial committee,
Yep.
instead insert the word, after has, insert the word either.
Yeah, I'm going to tell you just flat off, I'm going to be opposing both of these or proposing a substitute.
That's fine. And I'm
Okay.
cool with whatever passes, but I prefer this one, so I'll put it forward.
Okay.
And after the word, in that same sentence, after the word disputes, insert or held a convention to resolve the dispute.
That's very wordy. Are you sure?
That's, yeah. It's so that it would eventually read, if the affiliate has either its own judicial committee authorized to resolve such disputes or held a convention to resolve the dispute, the decision of the body shall be respected unless it is erroneous by clear and convincing evidence.
Okay. So that's what you're moving?
Yes, that is what I am moving. And if Mr. Bracco wants to move the last part of the amendment, you know, it doesn't break my heart, but I prefer it like this.
I don't have controls. I'm putting myself in line when we get to debate. Did you wish to speak to your motion, Mr. Rolette?
Only in that I think being prepared for these disasters, and they are disasters, okay? Being prepared for these disasters, I don't think makes them more likely to happen. Whatever we do, we must be prepared for these and have a way to deal with them rather than relying on tradition. Relying on tradition it makes it takes it from a tropical gale shitstorm to a category 5 shitstorm. Like, it's not good when these things happen, but being prepared for it makes it less bad.
Okay, thank you. So I don't see anyone else's hand raised. I'm going to move, since they're separated, I'm not going to do it as a substitute. I'm going to do it one at a time. I'm going to do what I think is the easier one first, which is the second one that says, I want to strike or held a convention to resolve the dispute. And I'll speak to it in one. I'm just going to highlight it for now. Because so, in other words, I want to keep the original language. And here's why. This is already dealt with. It says that the National Committee will make a decision by using the affiliate's own bylaws. In affiliate bylaws, the convention, that is the deciding issue if it's a legitimate convention. But the fact is, if the identity of the leadership is in dispute, the convention's probably in dispute. And adding this just complicates it more. If there was a convention, it could be an illegitimate convention because using the affiliate's own bylaws, it wasn't the proper leadership that called it. And this will just become a race for both chairs as to who could get a convention called first. And then the LNC is somehow, but this is worse than what we have now. Putting in there that the affiliate's own bylaws will resolve those things covers the issue of conventions. In Oregon, when we had that one Oregon decision, I know some people were on that judicial committee. I'm not trying to criticize you, but what it did create was this precedent of whoever the Secretary of State recognizes. So what you do, if when you have someone who's trying to do a coup of the board, they just do it really fast and get to the Secretary of State's office first. This is just going to cause competing conventions. It complicates things. A judicial committee isn't the one in this. You have the judicial committee already in place, and then you have a dispute as the chair. Yes, you could probably come up with some situation where there'd be competing judicial committees. That's not going to be as common as a disputed chair. And we had this in Michigan, by the way. We had competing conventions on the exact same day. Which one was the right one? Which one does the LNC have to honor here? Because the whole identity of who could call the convention was in dispute. This is a nightmare. I'd rather not have anything than have that language. Mr. Bracco, then Mr. Rolette.
Sure. So first thing is, do you intend to strike the either that's earlier in the sentence?
Yeah.
Okay. So the second thing is, by not having some kind of mechanism where an affiliate can resolve this on its own. Because what I'm concerned with is the LNC has its agenda and the membership of the affiliate has its agenda. And the membership of the affiliate is the rightful people who should be deciding who's running the affiliate, not the LNC. So if there is a mechanism for members to basically push the reset button on the thing, then that mechanism should have priority over the LNC. And I think if we don't have some kind of language like this, then that is not the case. Basically, if you don't have a JC, but you would rather handle this by, say, a member petition convention, you're not able to do so if the LNC doesn't give you the time. So if you say your member petition convention is 3 months out, the LNC can definitely make a decision within 3 months. I think they actually have to. Isn't there like 30 days or something in here? So there's ample opportunity for the LNC to front run the membership of a delegate or the membership of an affiliate. And I don't think that's a good thing to build into our bylaws.
I'm putting myself in line again. Mr. Sazelsky, then Mr. Rufo.
Yeah, but I guess looking at this and Mr. Bracco's concerns, if the affiliates bylaws authorize a convention to be a special convention to be called to resolve it, that would be using the affiliate's own governing documents, and if both sides agree that the convention results are legitimate, then that's all upheld, at least from my view. So yeah, it seems almost kind of like you're saying, Madam Chair, a little bit redundant and probably more of a headache to mention a convention where if both sides agree there's a dispute and the bylaws allow a special convention and everyone agrees, let's have a special convention. But yeah, thinking at the Michigan situation where there were competing conventions going on either day, on the same day, that opens a whole different can of worms to figure out which convention is proper. I mean, that's a situation we've seen already. So I guess that's my view on this.
Thank you, Mr. Rufo. I think I had Mr. Sazelsky.
No,
Well, no,
I
I think-
just spoke.
Oh,
Yeah,
okay.
Rufo's up.
Oh, I thought that was, never mind. I'm sorry.
It's cool.
Kind of
No,
scattered.
that's all right.
Mr. Rufo, thank you.
I'm kind of like this kind of goes back to the point of I think we need to have a stronger bylaw as to what qualifies somebody to be an affiliate, which would help resolve these issues. The idea though that I just want to push back a little bit on the idea that a group of people can force the LNC to affiliate with them. I think that's dangerous. One is the LNC is its own organization. It's the National Party, the Libertarian Party, the National Libertarian Party is its own organization, and it does have rights of association. And if they believe that one group is not the qualified affiliate, they should have every right to not affiliate with that group of people. So I do think there is grounds for the LNC to involve themselves in these matters when the matters are contrary to what qualifies an affiliate to be an affiliate. That's where I think we're approaching. I still think we're just like I said last meeting. I still think we're approaching this backwards. I don't think the solution is to have a way to dispute it. We have a way to dispute it already. A way that does work. It doesn't always work to everybody's likings, but it has worked and it's been clean. And it's not made everybody happy, but it's been clean and it's worked and it's gone according to the bylaws as they exist, which is why I think we need to approach this I think the party needs to approach it from a position of what qualifies a group to be an affiliate and how that I don't think we're approaching this the right way. And I don't think we should be allowing people to force the LNC or the National Party to accept them as affiliates. That's not the case. The LNC, the National Party exists, and they get to determine, yes, you do qualify, you can be an affiliate. Yeah, you're the rightful affiliate based on this bylaw XYZ. There's no world in which a rogue group of actors should be able to manipulate bylaws and force the LNC to accept them as an affiliate. I don't think that's the right way to look at it.
Thank you, Mr. Rufo. I'm going to address a couple of these points. I'm thinking back on nearly all of the affiliate disputes. They've all had competing conventions. Because when you have a dispute, and it's usually in the office of chair, this here is a recipe for just causing the LNC having no choice but to disaffiliate. And I don't want that. Notice there already is the safety valve that Mr. Bracco was concerned about. If the LNC jumps the gun even though there's been a notice of a special convention that is allowed under their bylaws, and there isn't going to be a dispute, say there's a clean convention that's scheduled, that everyone agrees we're just going to handle it at convention, and the LNC is like, oh, screw you, we're just going to decide. That's why they're allowed to appeal to the Judicial Committee. That's the escape valve. The Judicial Committee will be like, that's not a reasonable because interpretation of the affiliate's bylaws, because remember, the affiliate still has the presumption of autonomy. And if an agreed upon convention has been called and the LNC is assholes and jumps the gun, it will get overturned by the JC. That's the way to handle this. This right here is a nightmare. I will absolutely vote on this committee, vote no on adding that language. It's a big, big mistake. It's already baked in there. I would like to address Mr. Rufo's concerns because I do want to push back a little. Affiliates can't be worried every time the LNC changes whether they're going to be considered an affiliate or not. We right now have some folks that are going to be running for the next LNC. I'm not making a comment as to whether they're right or wrong or anything like that, but one of their campaign promises is to disaffiliate multiple states. I don't want that to be a centerpiece of every LNC run. And when the LNC does have the freedom to whom it affiliates at the point of initial affiliation. And if a bunch of rogue actors come along and do things that seem super, super contrary, such as what happened in New Mexico, where they start violating member rights, the LNC already has the option. They can disaffiliate them. So I actually think all of those options are already in the bylaws and covered sufficiently, in my opinion. With all due respect, I understand Mr. Rufo disagrees, but maybe he doesn't after hearing me, but I think he still does disagree. But on this point here, this ruins the entire proposal, in my view. Mr. Bracco, then Mr. Latham.
So I guess this would be a parliamentary inquiry. Let's say that this amendment passes and we do have a situation that you brought up where the LNC jumps the gun. Let's assume that the affiliates convention is scheduled for 90 days from now. And the LNC makes a decision 90 days out from that convention. The language in the second to last sentence, provided such appeal is brought within 30 days of the decision. Does that mean that the appeal would have to be brought prior to the actual convention? And if so, would there hasn't been a resolution by the affiliates bylaws at that point? Can the LNC jump the gun legitimately, according to this, provided that they do so more than 30 days before the convention?
I can't really answer that as a surely parliamentary inquiry without getting into debate.
Feel free to treat it as just debate then.
Well, I'll try to steer clear from that a little bit. I can't think of, yes, technically in isolation, you are correct. But in reality, you're not, because I can't think of any affiliate bylaws that require that much advance notice for a convention. And if an affiliate can't handle its business quickly, then there's a problem. That's why 90 days is in there. The longest I've seen for notice for a convention is 60 days. And the LNC's decision, if there's an agreed upon convention, can be, we're going to honor the results of this convention. So I don't think in the real world that's a concern. I think in the hypothetical world it's a concern, but not in the real one. And I don't even mind bumping that to 120, but I don't think it needs to be. I think 90 is more than sufficient. Most conventions require 30 days or 45 days notice. The one that was 60 is a special convention in Michigan, and that's an outlier in my opinion. And this will have been brewing a bit before the LNC even just, says they're going to look at it. And with this deleted from here, I might be okay with leaving in the 10 sustaining members, because I think that builds in somewhat of a time delay. Let me tell you no, I'll get into the 10 sustaining members later. I think there might be a better way to handle that. I understand what you're doing there, and I'm much more sympathetic to that than this particular proposal. But so the parliamentary inquiry answer is yes, hypothetically. But hypothetically, a Martian can come to Earth and say, unless you kill 50 people, I'm going to rape this woman. Those classic, like, libertarian gotcha questions. I don't think it's a real concern. Mr. Latham, then Mr. Bracco again.
And I'm trying to find my place. So are we just talking about the stuff highlighted in yellow, or the entire proposal?
Yes. I'm moving to strike the things highlighted in yellow.
Then I'll wait, because my comment's to something else.
Okay, thank you, Mr. Bracco.
So I understand that you think it's hypothetical. I don't think it's all that hypothetical. I think, especially if you're trying to organize, like, for those who don't know, I was, within the last year, part of organizing a member petition convention. It takes a lot more work than what notice requires in terms of time, especially when your board is of zero help. So
you didn't have never mind. Sorry.
We had a different kind of dispute, yes, but it was still a dispute. It's not a leadership dispute. But just using that experience of how long it takes to organize one of these things, I don't think that more than 30 days is crazy. Now, putting that aside, let's say that it was scheduled for 90 days out, just as an example. And the LNC did decide to jump the gun. Would that affiliate have standing to appeal to the JC immediately, or would that convention have already had to take place?
That is a parliamentary inquiry. I think they would have standing. The appeal has to be brought within 30 days. That doesn't, in the appeal can be, because it doesn't say it doesn't give a time. Well, it does. As long as they bring the appeal within 30 days, I'm going to get in line for debate. I just want to answer your question. So go ahead, Mr. Bracco.
Well, I think that's sufficient. I think it is reasonable to assume that an appeal could be put together within 30 days. I am less sympathetic to the idea that a convention can always be put together in 30 days. I think one of these has far more logistics to it than the other. But if you don't have to have a convention within those 30 days to have the standing to appeal, I think I'm far more amenable. My concern with this whole thing, and why I made this particular kind of amendment, I don't want to create a catch-22 for affiliates who are trying to solve their own problems when the majority of that affiliate might disagree with the majority of the LNC. So I guess I am much more favorable to the amendment, given that it seems like there isn't a catch-22.
And plus, I actually don't agree with you with what you just said. If there was a violation of the bylaws that resulted in someone being the legitimate chair, I don't care if 99% of that affiliate says we like the other guy better. Bylaws cannot be waived, even with unanimous consent. It's not a popularity contest. It's a bylaws contest. And if the special convention can be done within the bylaws to resolve it, great. But to say, oh, well, a majority of the delegates disagree with the LNC is not persuasive to me. If that means a majority of the or members, or however you worded it, disagree with the bylaws, too bad. They need to amend their bylaws. The ruling authority on this for the LNC is the affiliate's own bylaws, not a majoritarian. Well, this was an unfortunate bylaw, because this is also what happened in Michigan. Michigan they corrected most of them, some very unfortunate bylaws that they had buyer's remorse for. Doesn't matter. It's their bylaws. And it violates the rights of other people to be able to rely upon those bylaws, just because one person might be more charismatic and be able to get a bunch of people to say, well, we hate those bylaws and we're going to ignore them. So with this in place, affiliates then will be put on notice, which right now I do think the LNC has that authority. I prefer to have it explicit for all the reasons Mr. Roulette gave. But now they're on notice that this is the procedure. These are the timeframes. It has to be within the bylaws. So I want to be framing these discussions and disputes within the context of bylaws, not 60% of the members want to disregard the bylaws. So if a convention is held that's congruent with the bylaws, you know, you got the LNC and then you have a JC appeal. And at some point the buck has to stop, and it's not a perfect system. But now everyone kind of knows more what this system is. Mr. Bracco.
I just want to correct the record here. I think it's a bit of a mischaracterization of my position to say that it is to disregard the bylaws. I am assuming that the special convention is called according to the existing bylaws that were in place prior to the dispute. So my thought is that, okay, you have this dispute. Who's the leadership? You hold a convention and you maybe remove somebody, or maybe I don't. Now it's getting a little wacky, but still, like,
no, I mean,
it
that's
might end with
legitimate.
Now we're filling the office of chair or whatever,
or amending
like,
your
that's
unfortunate bylaw.
sure, whatever it might be. Yes. So however the convention shakes out is however the convention shakes out, provided it operates according to the bylaws that exist or that are passed, whatever. So that is my position. I just don't want, if an affiliate is going through the trouble of doing so, that is what stands in the end, provided they did it within the rules. And I think at this point we're aggressively agreeing, but I
want to fight.
But I just wanted to point out, like, I'm not advocating for disregard the bylaws because you feel like it.
Okay, I'm just a little touchy on that one because that's my interpretation of what some people are advocating for in Michigan. They would disagree. That's what they're advocating for, to be fair. I'm telling you my point of view. Obviously, people on the other, I don't know, maybe there are some people I think that would actually agree with the characterization, but think it's okay to do that. But others would vehemently disagree with that characterization. I just wanted to be clear that we're bylaws focused rather than fickle focused. And Mr. Latham would attest to this. Back with the Oregon thing, there were competing conventions as well, and both of them were illegitimate, I think, but that's a whole other thing. But it seems like when the dispute is with chair, they both run off to call conventions. And
I'll be honest, I totally forgot
they did have competing conventions.
what happened. That's down the memory hole for me.
Yeah, it was complicated. I'm pretty sure they did. I could be confused as well. But usually there's multiple conventions that are at least implicated, because like even in Massachusetts, the members called a convention, but the leadership refused to recognize it. It always ends up being a little messy. I hope that this thing can't force affiliate. Well, actually, I mean, the delegate, I don't like using the word force. The delegates could pass a bylaw requiring affiliates to have a judicial committee. I would not be in favor of that. I hope this, if this passes, encourages affiliates to have a judicial committee. I know some people aren't big fans of them. I am. And I am, even though I think the judicial committee decision with me sucked, I accepted it. It's the process we have. It's not going to be perfect. I still am in favor of judicial committees. And if I can say that, I would think that most people should at least be able to. You're going to win some, you're going to lose some, but at least it gives a clear resolution. Mr. Martin.
Thank you, Madam Chair. Yeah, I know that there's people here with a lot more experience with these kinds of disputes than I have, but I will contribute the little bit that I have, which is that the conventions can be held in such a way as to really distort outcomes. And we had that here in New Mexico, where, you know, a lot of people were essentially prevented from participating because of problems with notice and technical problems and all sorts of other stuff. So I would not want to see the LNC's hands tied by having to honor the outcome of a convention that might be dubious. So I really think that letting the LNC have some flexibility here in how they handle things is really going to be the way to go, and I'll be voting accordingly. Thank you, Madam Chair.
Thank you. And I do want to say there is still a weakness here, and I'll tell you what it is, because it actually was in New Mexico as well. But again, there's never going to be something perfect. And then what the LNC would have to do in that circumstance, if they were so, this is language I used with the Oregon situation, if the LNC's conscience is so aggrieved, they always do have the option to disaffiliate. And in New Mexico, this is just very unwise of members over the years. Their judicial committee is made up of their board appoints the old board, the old bylaws, appoints the judicial committee, and like the half of the board can be on it or something like really crazy like that. So it's not a neutral judicial committee, but that's the only state I've seen that's like that. That's very unfortunate. And because of all the shenanigans that were pulled with the bylaws there, we kind of mutually disaffiliated each other, because to get into the argument as to who disaffiliated who, it's irrelevant at this point. So this is not perfect. You could have a judicial committee that the affiliates bylaws have it where the board is the judicial committee, but there has to be a point where, you know, it's done. And if the LNC thinks that this is just absolutely violative of member rights as a last ditch thing, they can always disaffiliate, though thankfully that's been rare. And I hope it continues to be rare. I'm somewhat disconcerted by the threats to disaffiliate states because you don't like what they post on social media. Because Paul will attest to this, back before the whole Virginia thing. The communications team on Virginia at that time was calling the LNC a bunch of Nazis, and I mean, directly attacking the character of the LNC. And nobody on the LNC ever suggested that Virginia should be disaffiliated for that. Like, you start getting into that, I don't know, that just makes me uncomfortable. I know other people might be fine with it. That's up to them, but it goes both ways. You know, you could have affiliates that are very friendly and affiliates that are very hostile. And I think they are both equally have the right to say what they want. So any further debate on the amendment to strike the highlighted language? We're going to take a roll call on this. So the motion before the body is to strike the highlighted language. So that would return that sentence back to the way it was proposed on the list. Madam Secretary, when you have an opportunity.
Oh, I'm going to say.
Oh, wait, Mr. Bracco had his hand raised before we started the vote.
Oh, I'm sorry.
Just a point of information. A yes would strike, a no would retain the language, correct?
Yes, yes. A yes would strike it. I'm sorry, I should have explained that. A yes would strike that language, returning it to how it was proposed on the list. A no would keep that language in. Okay, Ms. Arrowood.
All right. Arrowood, I'm going to say yes. Bracco.
Yes.
Sazelsky.
Yes.
Latham.
I'm going to expressly abstain.
All right, sir. Martin.
Yes.
Moulton.
Pass.
Right. Rowlett.
Yes.
Rufo.
Yes.
Right. Seebeck.
Yes.
All right. I'm going to come back to Mr. Moulton. Do you care to vote, sir?
I abstain.
All right.
I'll not be voting. I could tell it passes, but whatever the count is, you can let me know. And I'll not be voting.
7 yeses, 0 noes, and 3 abstain.
Okay, and just a reminder, it's Dr. Moulton, just to observe the formalities. Instead, it's not Mr.
Oh, I'm sorry.
It's easy to. Okay, Mr. Latham has his hand raised, and I'm going to raise my hand for the other amendment that I did have, or at least question. Mr. Latham.
So is it now appropriate just to speak to the whole enchilada in
Yep.
general? All right. So thoughts I had as I was looking at this, I number one think it's problematic, the identity of the chair, vice chair, secretary, or treasurer. So you're telling me that if an affiliate has a dispute over who's the secretary, that this needs to get escalated up to the national committee and possibly the National Judicial Committee. I mean, so that's number one, a big problem I have with this. And then the 10 members of an affiliate wondering, if this passes, and I just right now don't see myself supporting this, but who knows, it could change. That seems, disproportionate, right? So smaller affiliates, it's a higher level. So I'm just wondering if that should be a percentage, larger affiliates, that's a lower threshold for action. And then, we were just talking about exhausting administrative remedies during the public comment. And this process would create yet another layer of administrative appeal that someone with a dispute would have to navigate for coming to an ultimate, conclusion. And then so I thought this was very helpful to the sponsor to have these questions. And I'm just going to basically go through them. So this may take a minute. But so first question, is there any way to structure this dispute resolution so that the group which loses is more likely to abide by the decision that's made? Yes, I'm sure this is, and this isn't it. I'm not saying that maybe there ought to be some way to structure it, but this isn't that way. Do we instead want to refer these questions to legal arbitration? And I think that's up to the disputants within that state who are claiming to be the affiliate as to how they want to to resolve that. And so when we say we, I just don't think that's the national committee's call. Should we spell out that the group which the national party recognizes is entitled to all of the assets of the state affiliate, or is that just assumed? My sense is that that's more than just assumed. And maybe our committee chair can clarify that, but I have to believe that is spelled out somewhere. Do we spell out who gets CRM access, links from our website, mentions in the LP News, etc.? And again, I think that's just kind of up to the national committee's discretion. I don't know that that's proper stuff for our bylaws or rules. I'm looking at this fourth. I've never seen people make up and get along after these, but do we want to try to put in some sort of mechanism for that to happen? And again, yeah, perhaps, but my problem with this proposal is that because it seems to lengthen the dispute that would be put forward in terms of making it more involved, it seems to me the more energy you require parties to put into dispute resolution, the less likely that they're going to kind of come to terms afterwards. Although I saw a nice documentary about the Hatfields and McCoys, that apparently they've come together and they have joint gift shop, and you can buy Hatfield McCoy merchandise, and so good for them. So I don't know that that's always the case. All right, sorry for the digression, but maybe it makes a point that's relevant here. Other question, do we want to add language about whether or not affiliate parties can expel individual members for leadership dispute shenanigans? I certainly don't want to add such language, but could an affiliate do that on their own? I know my affiliate did expel a member for a time. We let that member back in. I would not like to see that happen at the national level or be authorized at the national level. In order to avoid having two separate conventions for two separate groups, do we want to impose a rule on the states, I presume a rule on the affiliates, that the winning group has to let the losing group try again at their next convention? And I don't think that I wouldn't favor such a rule, because there may be some scenarios where it's not appropriate to let the sore losers try again. Should the JC be involved in this process at all? If so, how? Is there any schism where a decision of the LNC would not be appealed to the JC if an appeal were available? If so, why have the LNC make a finding or ruling if the JC is just going to eventually decide it? And there's no guarantee that something that the LNC did would be appealed to the JC. And I throw out this concept of constructive disaffiliation, and that's kind of a lens that I look at some of these disputes through. Is a legitimate affiliate dispute, or is someone trying to get around suspending an affiliate through another way, and is that constructive? So I think that's just something I look for, but I really don't like the idea of the Judicial Committee being involved. I think our chair said on the list, let affiliates decide to figure out their own shit, and I'm kind of inclined to agree with that approach. So we're containing it and we're localizing it, and if we create a mechanism where they can escalate it all the way up to the national organization, then I think we're just prolonging it and letting it spill over local into regional and national. And let's look to Israel to see how that goes. Do we have to take out the non-interference clause in Article 5, Section 5 if this passes? What kind of actions by the LNC does Article 5, Section 5 protect affiliates from? Since I don't have that Article 5, Section 5.
It says the autonomy of the affiliate shall not be abridged except as provided in these bylaws.
Okay. Thank you, Madam Chair. So trying to find my right tab again. I mean, I look at this and yeah, the National Committee shall investigate and make a decision. I mean, it just, yuck. Sorry, yuck. It just seems really problematic. For that reason, it just suggests a lot of interference that will come down from the national organization. And there may be an argument in terms of uniformity that that's a good thing. I'm not of that persuasion right now. I like to think I'm open to persuasion. I'm not of that persuasion right now. Is there any other issue more pressing than this? And if not, is there any reason that when the time comes to decide on the order of items in our report, Commission, that this is not the first item? And I guess I am not seeing the pressing need to address this issue because I already think the mechanisms are in place to address these kind of issues. Again, but I remain open to being persuaded, but I just think the wheel has been invented. Can it be improved upon? Yes. I think this makes things worse though and not better. So thank you for letting me go down that list of questions and offering answers and my opinions.
Thank you, Mr. Latham. I'm probably going to go down that list as well, but I'm not saying much shorter, as if you were long. I'm going to address what you addressed. Like, I'm going to build upon what you said. You already laid the foundation. And you went where I went. 10 sustaining members in Wyoming, they have 40 sustaining members in the entire state. I'm not saying like there's an issue in Wyoming. I'm just insert bylaws here. I'm just saying that would be 25% of the entire membership. So I tend to think it should be 10 or a certain percentage, like maybe 10 or 1%, something of that nature. However, I think that's problematic as well. I think, and I'm going to disagree with Rob here. I think people look at the bylaws way too atomistically. We have another duty in the bylaws. There shall be only one state level affiliate. An affiliate is a concept. It's made up of its leadership. Who is the affiliate? It's their current board. If you have two people claiming to be the board, you existentially have two alleged affiliates in the state, then the national party is in breach of the bylaws by not ensuring that there's only one state level affiliate. So I don't think the LNC eventually, now these timeframes, obviously, there's some subjectivity as to how long the LNC can take if this doesn't pass. But the LNC has to decide at some point. They just have to. That's an obligation under the bylaws. So what if 10 sustaining members don't sign a petition that for some reason they're just a cantankerous bunch and don't really want to see it resolved? They like fighting with each other, or somebody has something to gain from it. Who knows? I can't come up with every hypothetical. I don't think it's optional for the LNC. So I'm not hostile to it saying upon a petition, but I think that creates a potential conflict in the bylaws. I kind of think the LNC needs to decide, but when does that 90 days run? So there maybe does need to be a triggering thing. So I'm kind of okay with that being in there. And I'm probably at the end of my spiel going to move to say of at least 10 sustaining members, or I don't know how to word it, or 1%, kind of the way we do it for appeal of a decision of the LNC is there's alternative. What is it? 10% of the registered delegates or 1% of the national sustaining membership. Whichever is lesser, whatever. But I think we need to make allowances for these smaller states where 10 is actually quite a bit. Though I still am kind of but I think somebody will appeal. Like, I think I'm getting into the realm where I said what Mr. Bracco is the problem I'm bringing up hypothetically valid? Yeah. Is it realistically valid? Probably not. And if you can't get those members to care enough, maybe that state needs to be disaffiliated. Maybe I'm answering my own question, because I think you do need a triggering event for that 90 days. And that is a very clean triggering event. So now to answer these questions. these questions were for the old proposal, so I don't think they're all relevant to this one. That more than 1 year thing, I think that's addressed in this proposal. So I'm not gonna deal with that. There is no way to make sure that people who are determined not to be happy, to abide with something, I don't think there's any way to, I think this actually, I disagree with Mr. Latham. I do think this actually will bring things to a resolution quicker. But if I were the type of person during the last JC decision that I disagreed with, I could have really exploded in the whole other way rather than abiding by the JC. I think you're dealing with personalities, and there's just no way you can avoid that. I think the rest of the party in general, as long as everyone knows what the path is going to abide by it. You're going to have a few people that never will. It's just the nature of human beings, particularly libertarians. No, we do not want to refer them to legal arbitration. We even have something in our bylaws that says, regardless of the laws of a state, we get to set our own delegate rules. I don't think we should be referring our disputes to outsiders. And legal arbitration could make a decision that's in conflict with the affiliates' bylaws. They don't know bylaws, they don't know Roberts, they don't know our party, and they could be violating the rights of members. This needs to be bylaws focused, and we cannot entrust that outside. When we start talking about dealing with your own shit, that includes the entire party as well. So no, I'm not in favor of that. We don't need to spell out that it's implied, as Mr. Latham said. If it's property of the affiliate, who's in control of the affiliate, it's like we don't have to spell out that when a new LNC is elected, they get the office building. I mean, it's just kind of part of it. I have seen people make up and get along after these. Let me give you a prime example. Guess who's the new Region 1 alternate? This won't mean something to everybody, but it will to the old timers. Richard Burke. Richard Burke was the leader of one of the Oregon schisms, and Region 1 elected him as the alternate. And Region 1 includes Oregon, and the people that are in charge in Oregon now are the successors to the group that was opposed to Mr. Burke in the past. So I do think it happens. And I think I could probably come up with some other examples, but Oregon was one of the biggest ones. And they actually started to make up. It was a healing process, but maybe 4 or 5 years ago. So they do. It does happen eventually. A lot of people thought people wouldn't make up after Portland, and it took a long time, but they have. Nope, we're not going to control over whether affiliate parties can expel people. Some allow it, some don't want to even open that door on the national level, because I don't want to open that door for national expulsion. That will be the Salem witch trials, and I don't think we want that. No, we can't impose rules on states about letting losing groups. Mr. Latham covered that very well. Yes, the JC should be involved. That's why we have a JC, and that's why we want to encourage states to have a JC. You got to have a buck stops here. And with I do. And the JC's not perfect, but you got 2 levels of review. So anyway, I think a lot of the arguments as to whether the JC should be involved at all actually get into fundamental existential arguments over whether we should even have a JC, because I think this argument can be made for anything that the JC gets involved in. And if you say no, I think your argument really is that we shouldn't have a JC. I don't think it's really about this proposal, and I believe we should have a JC. No, we're not going to take out the non-interference clause because there isn't a contradiction here. I know some people disagree. I think Ms. Mattson beautifully laid it out in the Delaware decision. You have to read the bylaws holistically. Everyone reads that statement and stops with the autonomy of the affiliate shall not be abridged, as if there's a period after abridged, and there isn't, except as provided in these bylaws. And this is a bylaws provision, so it would be as provided in these bylaws. Are there issues more pressing than this? I think there are, but I do think it's pressing. So kind of taking the middle ground here. So I am in favor of this proposal. Why? Because in its broad scope, it codifies what is the process now. The LNC is deciding, and this isn't the only people. You always hate the current LNC. That's just the way it is. The last LNC made decisions. If you want to go to an entirely different ideological bent, there were 3 decisions I think made that were very similar during the term of Steve Dasbach, which is a much more moderate or pragmatic, however you want to put it, LNC. It's inevitable. They are the governing body of the National Party. The National Party is a different entity from the state parties. We're either going to have a confederation of state parties in which we have some kind of unification with as much freedom as possible while keeping the roar to a dull roar, or let's not have a national party. I mean, if you're gonna have a national party, you're gonna have some of this. So I'm in favor of this because not only does it codify what we're already doing, it adds protections that aren't necessarily there, and it makes explicit the custom we've had since Oregon of recognizing a cause of action for constructive disaffiliation. I do think constructive disaffiliation is a thing. I think constructive a lot of things. Otherwise, you give the LNC a pass to base. For those of you who don't understand what constructive disaffiliation is, it's doing everything to if the LNC is wrong in a decision, let's just use Michigan. If the LNC is wrong in the group it recognized, it did in fact constructively disaffiliate the other group. Now, I obviously think the LNC is correct. And yes, there is a path to appeal there. And it doesn't even have to be under constructive disaffiliation. It could be under appeal of a decision of the LNC, but that requires petitions. It's not an automatic appeal. I would like a group that thinks they were constructively disaffiliated to have spelled out in our bylaws an automatic appeal right. And this would grant them that protection. So it's balancing the need of the LNC to be good stewards and make the hard decisions that they were elected to make, but not free reign to be tyrants, that there is a route to appeal that isn't the LNC. I'm going to move. Well, I'm going to let Mr. Bracco speak because I'm going to wait. I am, before we get to a final vote, going to move to do something here with this 10 sustaining members input, or at least 10 or 1% of the sustaining members of the party residing in that state. I think that's the best way to handle it. I'm not moving it yet. Someone might have better language, but that's where I'm going with that. Mr. Bracco.
So I'd like to do 2 things. First, the one question up there, the legal one, I would be so opposed to that. It's hard to describe. In our dispute, which was not even the kind of dispute that's described here, we spent more getting a few short legal memos than we spent on our convention venue. If you want to destroy a state affiliate financially, let's send it to the court system. So no, no. Now onto this section here. My intention when I put this on the list was there has to be some kind of mechanism, I think, to say, hey, LNC, please do something. Like, I don't want to just give them carte blanche to just, there's a dispute, we rule. Somebody's got to do something. I'm not really stuck on 10 sustaining members. I just went to, I think it's Article 5.2, which says you need 10 sustaining members to form the affiliate. So that was kind of the starting point. If people want to change it, I'm cool. I don't really care. I just don't want it to be so low that me by myself can petition the LNC, because that's just wasting time. Like, I don't know what the right balance is between dilatory or abusive and like too restrictive for small affiliates. I'm not sure. It makes sense. I get that. I would say that those small affiliates also have to deal with the 10 sustaining members to form the affiliate. So if it goes crazy and it ends in a disaffiliation, then to restart the thing, you're going to have those 10 sustaining members anyway. But that was kind of my thinking. Feel free to amend it. I would oppose taking it out completely and not having something, but I don't really care about 10 sustaining.
Mr. Latham?
Well, then if it's time for an amendment, just I think one suggested there on the 10 sustaining it is 10 sustaining members of the party or 10% of the 10% of the stating members of the affiliate, whichever is lower. That would be my amendment.
Not all affiliates have membership in that way. Okay. Yeah. Okay. Then can you type that out?
Yes, I'll put it in the chat.
Is it in the chat and I missed it?
Give him a second, he'll get it there. There it is.
Okay. Yeah. Give me one sec. Did you want to speak to that, Mr. Latham?
Oh, I hope it speaks for itself, but if we have questions, I presume we'll hear questions. And maybe maybe I should say 10% of the members. Oh, we're qualifying it as residing in the appropriate state. So I think, yeah, I just want to make sure it wasn't 10% of all
Did you mean
national
of the
members.
affiliate? Because capital P
Well,
party refers to the national party.
Well, I think you got that next clause residing in the appropriate state.
But
So
that doesn't mean,
shouldn't that modify both?
I think you're misunderstanding it. So this is a question to you. I think your intent, and if it's not, let me know, is that you meant of the affiliate party.
Well,
That's
so
what
but
you said.
That's what I said. That's not what I typed because as I kind of typed it out, I thought, well, that the whole issue is you might you're in the middle of an affiliate dispute.
Okay.
And so you're going to have party members, but are they a member of the recognized affiliate or the folks that want to be the affiliate?
I'm going to ask you another question because I'm going to give you the opportunity to fix it because we don't know all the members of the 10% of the members of the party, a member of someone who signed the pledge. I think you meant to put sustaining there.
Yes, thank you.
I'm going to get in line behind everybody. So we had Mr. Bracco, then Mr. Roulette.
I'm actually going to pass. I was in line to amend it to put sustaining there.
Okay. Mr. Roulette.
I'm opposed to this amendment for basically two reasons. First, I think it makes it a little bit more complicated than it already is, which is not a large cost to bear, but it is a cost. And from a practical perspective, Delaware is a pretty small affiliate. It competes with Wyoming and DC as being like the smallest. They're not big, and they got 10 people on a snap. And I'm pretty sure, if memory serves correctly, they got at least 10 people from that affiliate engaged immediately in their dispute. I don't think that 10 sustaining members is too high a bar for this to come to the LNC. I think it's a good enough bar to achieve the end of like no dilatory crap with just a few people. But I don't think it's anywhere near too high.
Okay, well, I was behind Miss Roulette. I don't know if it was 10 sustaining members in Delaware. They were certainly Delaware members. The issue of whether they were National Party sustaining members didn't even come up. So I have no idea. Did we wait? Maybe I do have an idea. No, Massachusetts is where we filed a petition. Delaware was not a petition. That was done under an automatic. We were arguing for automatic. 10 members in Wyoming would be an issue. Because of also how spread out it is. And I don't think we should put undue weight on smaller affiliates. So when I said that my hypothetical problem of the LNC not being able to do something unless there is this petition conflicting with the other bylaw that says they need to ensure there's only one state level affiliate, you're forcing them into a disaffiliation situation that could be avoided. I do think I'm not going to do a substitute because I don't want to make things overly complicated. I am encouraging everyone to vote this amendment down. And if you do vote it down, I will offer the amendment that I suggested before upon petition of at least 10 or 1%. 10 says, I'm trying to come up with an elegant wording, but I'm going to just say upon petition of at least 1% or 10 sustaining members of the party, comma, whichever is lower. That I think is much more fair. And it doesn't create that potential hypothetical where the LNC is required to do something but can't, and then the only option they have is disaffiliation. But it solves the issue of when does that 90 days run? It gives a triggering event, which I think is really important to have so that timeframes are clear. But 10% is far too high, I think. So, well, maybe not. 1%, 10%. So if there's 40 members, Wyoming, I think, is 45 right now. I'm not math. Math is hard. What's 10% of 45? 3?
4.5.
5. I might be fine then with this, except for I just don't like the way it's worded. I think it's very wordy. And if it was going to say this, it should say upon a petition of at least 10% or 10 sustaining members of the party, whichever is lower. I think this added a bunch of different words in here. So I'm not making any motion. I'm actually okay with 10%. I'd be happier with 5, I think, but I'm fine with 10-10. That makes a symmetry. Mr. Bracco.
I would be extremely cautious of lowering this percentage because it does say whichever is lower. If it was 1%, then that means that any affiliate with a membership less than 100, sustaining membership less than 100, an individual member can petition. Math here is going to be like 5%. Let's say an affiliate with 50, and you have 5%. That means 3 members can petition. Do we really want 3 members? Like what is the minimum?
3 for a state like Wyoming.
And I don't know if you can see it, Madam Chair. I do have my hand up, but I can wait.
I do see it. I don't know if Mr. Bracco was done.
Yeah, I'm just pointing out, like, we shouldn't go too low with that percentage because otherwise we're defeating the point.
What is the point?
To keep dilatory petitions from being sent by like 2 people.
Then I think it would be relatively quick for the LNC to just say it's not valid. As an LNC member, I'm not concerned about that. Mr. Latham.
Well, on that, but that does touch upon, I think, why I just really have a problem with this whole thing is the potential for, some small group manufacturing a dispute and that occupying, the National Committee and potentially the Judicial Committee's time in resolving that dispute. And so actually, I was wanting to make a substitute because I think we are trying to find that Goldilocks number. But yeah, 1% I thought was way too low. I did the math on 10 divided into 45. It's 22%. So I was thinking 25% or lower if we were going to do the or lower. Because as Mr. Bracco said, yeah, you can really get a small number if you're just going to say 1%. And I don't mind saying upon a petition of at least 10 or 25% of the sustaining members of the party. So that way we take out the duplication of sustaining members of the party, whichever is lower. So that would be my substitute amendment if we can work it that way. But that also includes changing the number to 25. And maybe, Madam Chair, that was what you were intending to do, just upon petition of at least 10 or
Okay, I think
25%.
Yeah, I think the committee as a whole, without going through a formal amendment process, if nobody's rights are being violated, can just leave this language on the screen as it is and realize whatever number we settle on, it's going to go in that form we just described. Upon a petition of at least 10 or X% of sustaining members of the party, comma, whichever is lower. So let's not move stuff around right now if we can all be fine with cleaning up that language without burning a lot of time on that. So basically sounds like you're moving to amend your amendment to strike 10 and make it 25.
Yes, please.
Did you wish to speak further to that?
I'm just throwing out a number that seems to make the most sense based on our existing conversation, but I'm negotiable and persuadable on it.
Okay. Mr. Martin, then I'll put myself in line.
Yeah, I don't get the 25%. Using the case of Wyoming with 45 people, that would be 11. Well, 12 actually. Mm-hmm. So you're actually raising the threshold there, not lowering it. So I guess I've either missed something or a mistake has been made.
And if I can just, the initial number thrown out for Wyoming was 40. So I said, what's 25% of, or sorry, how do you get 10 from 40? And that's 25%. But yeah, you're right. It adjusted. So maybe we need to adjust the math a bit.
Yeah, it's next in line. I think just some of us are viewing this fundamentally different. There's some people I think in this, well, maybe, I don't know, maybe I'm tied. I've been on the LNC a while. I don't have this big concern about a bunch of dilatory things. I think they'll just get disposed of quickly. The LNC has to deal with business. That's their job. If this kept happening a lot, the LNC is able to delegate investigation to a committee that's dedicated just to doing this. Fiddling around with this number out of some kind of concern for the LNC, unless Mr. Rufo has a different concern. As a member of the LNC since 2016, I can't tell you how unconcerned I am about that. And considering that during that good part of that time, a lot of that work would fall to me because I happen to like bylaws and read them. If I am thoroughly unconcerned with that, I really don't think the bylaws committee should be. However, 25% is too high. 10, I could live with. 25, I'm encouraging everyone to vote that 25 down and leave it at 10. Mr. Rufo.
Yeah, no, I really I'm concurring more or less. I don't really care what the number is, honestly. I don't think it's a real issue. The LNC could easily dispose of these things and move these things forward if necessary. I completely agree. I will say that it says 10 or 25%, whichever is lower. So if the concern was this would make it harder for Idaho because they would need 12 or 13, that's not that I think we're missing, because you would be able to, Idaho would be able to do just 10 people and not have to be forced to do the 13 or whatever the math works out to be. I don't think the number matters. I personally don't care if it's 10 or 25%. This will, no matter, because you guys got to remember, like, we're not the final determination of what the final language of this is going to be. We're going to put a number out there. We'll throw a number out there. The delegates, if this gets up to them, are going to debate it, and they're going to amend it, and they're going to change it. And then there's going to be a huge debate about it there. We don't need to debate this ad nauseum. Let's just pick a number, move forward, put it out there, and let the delegates do what they will.
Thank you, Mr. Rufo. I'm going to address some of that. The idea is to put forth language that's good so that it doesn't get to the amendment portion, because the way our convention rules work is it's open for debate without amendment for 10 minutes, at which point it goes to an up or down vote. We want it to get an up vote if it's going to pass, and not go into an additional 8 minutes and eat up more time. So I actually do think it behooves us to get the right number. The whole idea of adding a percentage was to make it lower for states like Wyoming. Adding the 25% made it higher. 10 is too high for Wyoming. So we need to come up with a percentage that makes it lower for those smaller states. 10% is that number, not 25. And yeah, I don't know who said this. I'm sorry, I lost who they were, but I want the committee not to lose sight of the fact that there was an objection earlier to those 4 officers being named, and I think that was legitimate. Let's not forget about that issue when we're disposed of this part. Mr. Latham, then Mr. Rufo again.
Well, I don't know if I can do this, but I was hoping to replace 25 with 20.
No, you can't. We're 2 amendment levels, Steve.
All right.
Mr. Rufo.
I get it. I understand what you're saying about the not wanting to get to the amendment part. I understand that. Also, but I do personally kind of think it should be a little harder to do these. Not because I think the LNC will get overwhelmed. I don't think the LNC will get over. That's not my concern. I just don't think it should be too easy to constantly be throwing petitions at. Like you should have to work. And if you can't get, a sizable amount of people to want to dispute something, is 25 a little heavy? Probably. But it does say whichever is lower, right? Like 25% of the sustaining members or 10. So like nobody really is outside of Idaho would have to do more than 10. And I get that it would be hard for them, but I don't know. I just don't think it matters at this point. I think 25 works. I think 10 works. You guys do whatever we want here, but I think neither one of them is bad.
Okay. Thank you, Mr. Rufo. 25% then is meaningless, and we should just strike the whole thing, because the whole idea of adding a percentage was to make it lower from some states. This would make it lower for precisely 0 states. So that makes that whole phrase completely unnecessary, because nobody's going to do the 25%. They're going to do 10. And if the 25% doesn't make it lower for anybody, there's no point in even having it there, because that was the whole point. And this is making it higher. No one will use the 25%. However,
yes, that's what I was trying to say.
Yeah.
Thank you.
Yeah. But however, I don't view, I'll be, if the thought of the committee is to make this a gatekeeper before the LNC can make a decision, that's not how I'm viewing this at all. Because I think the LNC is forced by another bylaw to have to make a decision, even if 0 people. If there's a legitimate dispute, this puts us in trouble with the FEC. It could screw up our ballot access. The LNC has to make a decision if there's a legitimate dispute, even if no one ever petitions. However, that's just a hypothetical. Someone's going to petition if the number is reasonable enough. I only want this petition in here, not as a gatekeeper for the LNC to have to decide, but as a triggering event for the 90 days. Because otherwise, when does that 90 days run? From the minute we might have heard a whisper in some shithole Facebook group that there's a dispute? Like, we have no idea when that 90 days runs. We need a triggering event that is clear. And the petition does that. But I don't want to make it so hard that it's in 10. I'm not looking for this to be some kind of, they have to work for it, because I think the LNC has a fiduciary duty. If there's a legitimate dispute that is causing issues with people filing campaign finance, 2 groups filing campaign finance reports, we have to do something, even if no one complains. So let's put it to where there's a triggering event, but pretty much guaranteeing if it's gotten to that point, that that number of people will complain. And it's more gives you identity of people to invite to the meeting where the LNC is discussing it. So you know, okay, these people filed a petition, we're going to have a special meeting on this date, please come, type thing. But I'm not looking to create a barrier here. I'm looking to create a triggering event. Mr. Latham.
Well, I was going to ask if it was appropriate to withdraw my proposed amendment.
If there's no objection from the committee, you can always ask to withdraw.
Okay, that'd be my request.
Is there an objection from the committee to withdraw the 25% so that it's back to 10? And then I understand Mr. Latham's probably going to try to amend it to 20, which I'm going to oppose. I'm just letting you know that, in case that makes any difference at all, so that we don't go through all this again if that makes a difference. If it doesn't, you're perfectly free to. Is there any objection to withdraw the 25? Hearing none. It's back to the 10. Mr. Latham.
Do we need to, I guess we need to vote on that first. Well, I'm going
No,
to go.
You can go another amendment level deep because you got rid of your second level amendment.
Okay. I wasn't going to go with 20, but how about 15? Because I think we're still trying to find a lower bound. And so I think 15, if 20 still wouldn't apply to anybody, 15, that's 1/8 roughly of a membership, maybe a little more than 1/8.
Thank you, Mr. Bracco.
I just want to say I am no longer trying to care too much about these numbers. The 2 members of the LNC have both pretty strongly stated that they're not too worried about this becoming spam and dilatory stuff. So I would say we should vote this down and just stick with the 10 and just go with this. And I think we're overthinking this by a lot.
You took the words out of my mouth, Mr. Bracco. I'm going to charge you for them. Okay,
Intellectual property is fake.
Is there, Mr. Latham?
Well, I can read the room and I'll withdraw that amendment too.
Is there an objection to withdrawing the 15% and leaving it at 10? Seeing none, it is back at 10.
But I do have another proposed amendment.
For
we
the
got to
same
still vote on
section?
the 10 though. No.
Okay, so we're going to put this in that better wording. So it would be, how is it again? Oh my God. At least, what was the wording we agreed upon, Mr. Latham?
I thought it was at least 10 sustaining.
10 or 10%?
At least 10 or 10%, whichever is lower.
Okay. Or 10%
of
the sustaining members of the party, whichever is lower. Okay. So the highlighted language is just the the more elegant wording of the same thing we were all just talking about. Mr. Bracco.
Since we are doing things very dirty with this, I would suggest that we put the whichever is lower after the residing in appropriate state. It kind of reads very strangely this way. So I guess it's not a motion, but
I don't
sustaining
want to
members
get,
of the party residing in the appropriate state, whichever is lower. I don't know. Maybe neither one's good. I'll be quiet.
I'm going to throw a different monkey wrench in there. I don't think whichever is lower is even needed. I think when you say this or that, that implies it's this one or it's that one, and you get to pick. If you for some reason want to pick the higher one, you have every right to do it. I don't think whichever is lower is even freaking necessary.
And I don't object to that.
Does anyone object to getting rid of whichever is lower? Okay, we've made it much more elegant. So it would read, upon a petition of at least 10 or 10% of the sustaining members of the party residing in the appropriate state. Is there any further amendments to that? Is there any objection to this amendment?
Yep.
Okay, we'll take a roll call vote. Madam Secretary, so a yes vote would insert or 10% of the, and a no vote would just leave it at 10.
Arrowwood. I'm going to say no. Bracco.
Yes.
Sazelski.
Yes.
Latham.
Yes.
Martin.
Yes.
Moulton.
Yes.
Rowlett.
No.
Rufo.
Yes.
All right. Seebeck.
Abstain.
Madam Chair, at this point, we have 6 yes, 2 no, and 1 abstain. Do you care to vote?
I do not care to vote. This passes. We are, well, actually, we got 13. No, we got 6 minutes because 8 minutes because we started 5 minutes late. Mr. Latham's hand was raised first. I'll go next in line. Mr. Latham.
Had a proposed amendment. I put it in the chat just after that, right before actually that first petition. Should we do upon receipt of a petition? So the petition's got to actually be sent, not just signed. But I'm happy to hear why that may not be appropriate.
Okay, I'm going to allow some informal discussion. We're getting back into overthinking mode. I think we're getting into Will McVeigh territory, which is our bylaws just say notice has to be given. It doesn't say anyone has to be able to see it. So Alicia Matson said, so if I send you a question with white font on a white background, did I actually send you a question? I don't think that's necessary. I think you're getting way into overthinking mode here. But I'm leaving it up to you. That's my thoughts.
Well, I'll throw out, I'm seeing the sentence that says upon notification of such a dispute. So I presume that notification comes via this petition. If I'm reading this right,
I would
is
agree.
that?
Yes, that's
Okay.
my understanding.
All right. So I I think that covers that. So no need to make that amendment.
Okay, so I was next. There was concern, and I agree with it. When I wrote this, I wasn't really sure what to do with this. Where people were like, if they can't agree who the secretary is. And while I personally do think secretaries do a very important job, I don't think they necessarily rise to the importance of here. Chair and vice chair do, because you might have a vacancy in the chair where the vice chair is actually functioning as chair if their bylaws have some kind of thing against auto ascension, and that could, what we're trying to do is the key people that would legitimately cause there to almost functionally be two affiliates. And the reason I included treasurer, because Virginia, I'm thinking of Virginia, got very fortunate in their thing. I know it isn't exactly what's contemplated here, but it is an object lesson where they were fortunate that their treasurer was one of the good guys. So we weren't arguing over the money, but I think treasurer is a key enough position. I'm not really so sure how to word this. I don't have an amendment. I think dealing with that very valid objection is the next most important thing with this proposal we should deal with, rather than tweaking other language that isn't really substantive. I think that's really substantive, and maybe just striking secretary. I don't know what to do. I was going to put key leadership, but that's so subjective. Maybe just leave it as chair or vice chair. And, if it deals with money, treasurer absconding with something, then maybe the state needs to deal with that within the state courts or whatever. The LNC could always assist in whatever way by writing letters, or so maybe it just needs to say chair or vice chair. And the reason chairs, vice chairs is in parentheses there is some states have they have Eastern vice chair, and they have we don't do that in Colorado, so it's kind of baffling to me, but a lot of states have multiple vice chairs. And it's not always first and second, because I wouldn't have a problem with it saying first vice chair. Sometimes I don't know how their bylaws deal with it when it's like northern and southern. There's a few states that do that. So Mr. Cizelski has spoken less than myself or Mr. Bracco. So Mr. Cizelski.
I was raising my hand to potentially tweak some other language.
Well, go ahead. I just don't want us to forget about the issue in the first sentence. You have every right to look at something else.
Okay. I'm hoping this is simple, but where it says if the affiliate has its own judicial committee authorized to resolve such disputes, I was hoping to strike judicial committee and put process, or maybe body. I'm kind of open to either there. And that's just because even though judicial committees, I think are probably the better solution. I know, like the current, for example, the current Georgia bylaws do not have a judicial committee, but in the process described in the current bylaws would not have any authority over an internal dispute, but it would be within the realm of possibility in my mind that that process could be much easier amended if the membership there wanted to allow that kind of dispute. And the way that they did it, I guess, would kind of qualify as judicial committee, but it's described as an internal arbitration board where basically sides pick, this side picks someone, that side picks someone, and then both sides have to agree on a third person, and that three-body panel would make a decision. So I was just trying to potentially open this up a little bit to maybe less normal dispute resolution methods.
I don't know what your actual amendment is.
Strike, I guess let's so if the affiliate has its own, strike judicial committee and put process.
Mr. Bracco, I'm going to have you first.
I guess I was going to do a different amendment, but I can come back to that. I'd actually like to speak to this. I feel like we've kind of covered this. with the whole convention thing. I would think that the resolution for, oh, your bylaws don't call it a JC or judicial committee, it's this other thing, is kind of the same as my concern with the special convention. So if the LNC tries to front run the your process, then you just say like, no appeal, and it goes to the national JC, and hopefully that's enough incentive for the LNC to not front run the process, but probably someday it won't be. I kind of feel like we've covered this sort of thing. That's all.
I was next. Yeah, I think this has been covered. We don't want to broaden this. And okay, some states might not call it that. We need to start to on things that can rise to the LNC to incentivize the states to standardize some things. If they want to have it where it's very clean and their own things resolve it, then they can amend their bylaws to call it a judicial committee, or they can choose not to and leave the ambiguity. But we can't have every single, this is, I think we're getting into overthinking it realm again, and within their own bylaws is already covered earlier, and just calling it process, again, I'm thinking of current disputes. Well, what if they just say, well, the process is, most of the board thinks it's this guy, even though it's clearly against the bylaws. That's the process. You have to know it needs to be something official, and the culture and terminology in our party to where it's almost become a term of art is judicial committee. That's what the national committee has, what we're familiar with, and what we need to work in the framework on. And state affiliates can conform to that to protect themselves or not. But I don't think we should be adding an ambiguity, and this adds a giant ambiguity, and I'd be opposed to it. I'm not going to make this motion, but I'm going to express a little bit of frustration. This was on the list 2 weeks ago, so we'd have these discussions on the list and not have a whole meeting on this and not get to a resolution. So we're at time right now anyway. So unless we move to extend time, this is going to go to another meeting and we're not going to hear everyone's proposals. Or someone can move to extend time to move on to another one and postpone this to the list again. When we move something to the list for workshopping, I have to beg you guys, you need to workshop it on the list. That was the whole purpose for putting it on there. I don't know who's next, but Ms. Arrowwood hasn't spoken in debate at all, and her hand is raised, but we are at time. Someone needs to extend or do something to allow us to continue.
I would prefer to finish this up tonight, if at all possible. And so therefore, I would move for an extension.
Of how long, Ms. Arrowwood?
Oh boy. 15 minutes?
Okay, there's a motion to extend time for 15 minutes. Is there any objection to that motion? Hearing no objection, did you have a debate point as well, Ms. Arrowwood?
No, I just feel that we have so much in front of us that it would behoove us to finish this up tonight, if possible.
Okay, thank you, Mr. Sezelsky.
I guess if no objection, I'll withdraw.
Is there any objection to withdrawing that amendment? Mr. Bracco, were you objecting?
No, I'm getting in line.
Okay. Mr. Bracco? So it's withdrawn. Mr. Bracco?
I would like to move to strike the comma secretary, comma or treasurer, and replace the comma between chair and vice chair with the word or. So it would just read chair or vice chairs. I believe that the secretary portion of this change has already been adequately spoken to. I think you need a secretary, but as long as they're doing their job, I'm not sure that it rises to this level of criticality who specifically that secretary is. If the secretary is the only position that's like up for dispute, I kind of feel like the rest of that board or the affiliate would be able to handle it. Yes, it's money, but I kind of feel the same with treasurer. The benefit of having treasurer in here is that the treasurer, if that's the only position under dispute, or then it can go to the LNC. I don't think that, like, I think if, say, the chair and the treasurer were under dispute, then it's like, well, how do you resolve this treasurer dispute? I feel like the mechanisms should and likely do exist in most affiliate bylaws to resolve a treasurer and only a treasurer dispute, because the rest of the board would still have the leadership to be able to act. And I think that's why just have the chair and the vice chair. So if you have a position where the leadership of that affiliate is unable to act because of the dispute, then it goes to this. Because if you had chair and vice chair and secretary and treasurer, that still qualifies. So we wouldn't lose anything there. We'd only lose the very specific cases of it's only secretary, it's only treasurer, or it's the combination of the two.
Thank you, Mr. Bracco. I have a question for you. In which case you might want to amend your amendment. Because now that without those other two terms there, I'm seeing things clearly. I think the real key position is chair. And the whole reason I put vice chair there because of the whole ascension thing. And maybe that should say chair, or in the absence or vacancy or something like that, when there just isn't a chair, then the vice chairs. So that way, what if the chair's not in dispute, but only the vice chairs are? Doesn't the affiliate have the capacity, just like for secretary or treasurer, to resolve that? I think they do. So I think what we're trying to get at here is the head honcho. But we don't want to just say chair, because there can be situations where somebody technically has the title of vice chair, because this is how New Hampshire works, but they're acting chair. They're running the party because they like to say the chair is vacant till the next convention. That's just how they work. And I think that's what they're doing in New Jersey right now too, from what I understand. So yes. I think maybe we need to word this as what I said. I just don't have the language yet.
I think it's just chair or acting chair.
But what if the acting, okay, and maybe I'm overthinking it. What if they decide to appoint someone, like their bylaws allow them to have a chair that doesn't necessarily be a member of the board? I don't know if any affiliate parties do that, honestly, but that's not unusual in nonprofit boards where your officers don't have to be board. Actually, this came up in Idaho as to whether the officers were actually members of the executive committee. I might be having my terminology wrong, but there was a question about that in their bylaws. I don't know. But I think it's another flaw. I don't know how to fix it. Yeah, party liaison is way too ambiguous. And let me just say, if we, then I'll shut up. If we say chair, I think in principles of interpretation, if they're called something else, but they are functionally the chair, it covers it. We don't need to get into all this really vague language for the same reason where it says here, well, we say affiliates own governing documents, but let's say it said affiliates own bylaws. Well, New York doesn't have bylaws. They call their bylaws rules. Would this mean we wouldn't look at it? No, because Roberts even says your set of documents that does X are your bylaws, no matter what they're called. The person who fulfills the role of chair is the chair, no matter what they're called, I think, unless it's actually a vacancy in a literal office. So I think we need to cover that loophole without getting overly hung up that some state party might call them the grand affiliate poobah and make them wear a Shriner's fez. Like, presiding officer is interesting in chat. That's a potential. Anyway, continue. I don't know whose hand was first. Mr. Roulette. Well, it's between Roulette and Rufo, who has spoken less, but I think it's Roulette.
I'll keep it quick. Chair or vice chairs is simple. It covers 99.9% of everything, and so I'm in favor of chair or vice chairs.
Thank you. Mr. Eeny, Meeny, Miny, Mo, Mr. Latham.
And I put this into chat. We've got an occurrence of its affiliate, and we're going back and forth with unaffiliate, the affiliate. And so I guess maybe we can conform this without a formal motion, but I was wondering if we could just make that consistent. And
We're
then
in
just,
the middle of an amendment right now, so that's out of scope.
okay. And there's a comma that needs to be added after state too.
That's still out of scope. We're dealing with or, right? The striking of secretary or treasurer, and adding or. Mr. Bracco.
So with this discussion, I'm okay with striking vice chair. I'm okay with keeping vice chair. What I don't think we need to do is bend over backwards for affiliates, because like we've already set the precedent where we're not really bending over backwards for affiliates that don't have a JC.
Mm-hmm.
Like it's not specified. And there's a lot more than 2 affiliates that don't have a JC. If we're okay not bending over backwards for those many more than 2, like just have your vice chair fill the role of chair and call it chair. Okay. Like that's not even that big of a deal. That's not a real change. Like at least adding a JC is a real change. That seems goofy. And I don't think we should bend over backwards. I'm okay with chair only. I'm okay with vice chairs, but I don't think we should get too complicated beyond those 2.
Mr. Rufo.
I agree with Paul. I think we're overthinking it. In trying to respect the nature of why we went with this proposed amendment in the first place, I think striking vice chair is the correct move. I think, Madam Chair, you were right in the sense that we really just needed to say chair. And I think we started overthinking it. It just needs to say chair. Everybody knows what that means when we say chair. Everybody knows that presiding officer is assumed to be the chair. I think that's just leave it. I think we should just also strike or vice chairs and leave it with just chair. Can I propose that?
Yeah. So are you moving to
Yeah, I'm moving to, I guess, amend the amendment to strike or vice chairs.
That's not technically correct, but I'm going to allow it because I think it's going to get us where we're going to go. Just technically.
I know I'm missing a step somewhere in how to do this.
I know, but I to me,
we're on press time, and I think we all want to actually resolve this tonight.
Yep, and sometimes form over function isn't we want function, even if it's not technical. Okay. I think you spoke well to that. I'm just worried about fellow autists in the party. I'm wondering if it should say chair / presiding officer, but I'm okay with chair. Just throwing that out there. Is there anything further? Mr. Bracco.
To clarify, this amendment to the amendment would strike the or as well, correct?
Yeah.
Okay.
What the way I'm doing this is very unorthodox. The amendment to the amendment is to add to your strike of or vice chairs. What he's actually doing is a substitute, but it's a second level. So we're doing it this way because I think everyone understands what we're doing here. So is there any objection to adding to Mr. Bracco's strike also vice chairs. So it would just be chair. Okay, so the amendment we're on now is to strike that entire phrase, that entire section there. Or vice chairs. So that it would just say chair. Whatever we need to do is get rid of vice chair, secretary, and treasurer so that it would just say chair. Is there an objection to that? Okay, seeing none. Good. We did this very unorthodox, but we all knew what we were doing and nobody's rights were violated. So I think that's where we're at, Mr. Roulette.
Move to replace the word state with the word affiliate.
And where is that?
On the right. Hold on. Zoom in. My damn computer. Where did it go?
Right in the
It's in
middle,
there
third
somewhere.
line. Is that it?
Yeah, correct.
Well, they are residing in the appropriate state, though. Okay, I mean, you're free to make that.
And the appropriate affiliate. Like it keeps
Okay.
affiliate standard. If it's controversial, I won't worry about it.
I had the same idea and then I withdrew it for the exact same reason. Our chair said,
If
because
anybody
it's,
cares, then I'll
yeah,
withdraw.
it's more
Okay, then I'll
geographic
do it.
than
Yeah.
affiliational.
And I want to give you another reason. This phrase appears also when you're talking about credentials, that you have to submit at least one delegate who resides in your state. It doesn't say you're a affiliate. And I'm sure there's a reason for that. Because perhaps, yeah, yeah, because they might allow not out-of-state members. I'm a member of Pennsylvania. So I'm a member of the affiliate. Am I residing in the affiliate? I think I'm a member of Minnesota now too. I think saying state makes it clear that you're talking about the geographical boundaries, even though that state might allow members of its affiliate to be out of state. Mr. Bracco.
I just want to speak to that same language. That's also lifted directly from the language that lets you start an affiliate. Now it's a little bit different, but I would just echo the sentiments of let's not fix what works.
Jonathan Jacobs, you can still be a member of Pennsylvania. You're just not entitled to voting rights at the convention. They still have out-of-state memberships. It's just a different level. From what I understand, Pennsylvania person, I guess, could explain that, but I'm pretty sure. Mr. Latham.
I just wanted to bring to the committee's attention this sentence, second from the last. Any persons claiming any of the disputed offices who are not recognized, since we made that singular and not plural, does that need to be fixed?
Yes.
So my motion is to fix it and just conform it to the singular rather than the plural.
Any person claiming the disputed office?
The disputed officer who is not recognized.
Oh, the disputed office? Oh.
Yeah, that's a little problematic still now.
I don't know how to fix it off the cuff right now, but Mr. Seebeck. You're on mute, Mr. Seebeck.
Sorry. Any person claiming the disputed chair position or something like that.
Chairmanship?
It's only singular. That would work. It's only singular, so.
So any person claiming the disputed chairmanship who is not recognized by the Libertarian National Committee.
There you go. I'll move that.
Okay. I'm just gonna start typing it here. Just any person claiming the disputed chairmanship who is not recognized.
Yep.
So it would be to substitute in that rather than the language which is right before it. It's to strike and insert, actually. Mr. Latham.
I think the grammar's still a little problematic. So I was just thinking, I mean, what are you disputing? So I think it's what you mean is you're disputing, if you're appealing, you're disputing that this chair is not recognized by the Libertarian National Committee. So it just seems like any person claiming that the disputed chair is not recognized by the Libertarian National Committee. You see what I mean?
No, that sentence you just said made no sense.
But you're disputing that the LNC is not recognizing that chair, and that's why you're appealing.
No.
Unless, okay, so what are you?
Well, I don't think you're disputing that they're not recognizing them, because they're not. You're disputing that their lack of recognition is correct.
You're just, okay. I just got to think that through. You're disputing that their lack of recognition is not correct. Okay, sorry, just have to, I'm thinking this out loud.
It's whether or not they recognize somebody is a fact. They either do or they don't.
Right.
The question is, are they right?
Yeah, it just, anyway, I just think it's a little off. I mean, I get the intention. I just don't think we're expressing that intention clearly.
How about any disputed chair who is not recognized? I don't know.
So that limits the scope to just that person being able to appeal.
Yes. And it was that way before too.
Oh, and that was it. And if that's the intention, then I think, yeah, I think that clarifies it quite a bit. So it's just that one person who can bring the appeal.
Yeah.
I think that's
because if they don't wish to fight it, it doesn't matter how. It's like the whole resignation thing. We're not going to accept someone's resignation if they want to quit.
Yeah.
Like,
and like where you phrase it that way, that now makes sense. But I would rather do the way you just rephrased it than what is written here.
I don't remember what I said.
If anyone does, put it in the chat or speak up.
I think I said any disputed chair, and probably be any such. I don't know. I actually think this wording is fine. So, Mr. Bracco, then Mr. Shebeck.
So I'm pretty sure we're over those 15 minutes. I'm sure there's some people who would want to extend, but I know there's some people who don't. I'll make the motion to go another 10 minutes, and I'm gonna object to my own motion and abstain.
Then we're going to have a vote, and there's no point to it.
Then we're done. Otherwise, we're like,
yeah. Then we're
time's up.
done. Otherwise, if someone's going to make the motion, no, you can't make your own motion and then speak against your motion. That's not the way it works.
Okay, then I won't make a motion.
Okay. Is anyone? Otherwise, we're done. So yell if you want to make a motion to extend.
Move to extend for this one amendment and no further.
What about if it passes, doing a final vote? Like,
no, because I don't know how many amendments people have in the chamber. Like, and if somebody wants to think about this over the course of the next 2 weeks, go for it. But I can imagine this going still longer. So let's get this amendment done. Let's leave it here. If people want to think about it, they can think about it.
actually, I'm moving to amend your motion to extend.
Okay.
I'm moving to extend for however long it takes to finish this proposal. And if someone wants to finish it immediately after this amendment, maybe call the question. I think we need to get through this. we're starting to get into the point where other people have things they think is important as well. And we kind of agreed amongst ourselves that we're going to try to at least get through everyone's proposals. We can't carry this over to another meeting. So I'm moving to extend to finish this, however long it takes, and that will motivate people to finish this. Is there any? I'm sure there is, and I don't want to go through a million rounds of voting. I know Mr. Seebeck wants to go, so is there an objection? I'm sure there is, but you have to say it out loud because I know there's hands in line. Okay, we're going to finish this. Is there going to be further amendments to this? One of you two in
Yes.
line? Okay, Mr. Seebeck.
Okay, first question, how deep are we at the moment on this?
Just one
Amendment
level.
wise?
There could be another
Okay.
amendment.
Then I wish to amend the amendment here to make a little better wording.
Okay,
So the highlighted part, we already put in, just rearrange the wording. So it's any person who claims the disputed chairmanship and is not recognized by the LNC. I think that'll clear up the confusion over the wording about what was raised in the chat about that who.
I oppose it. I'll speak to why when after you're done, Mr. Seebeck, if you are going to speak more.
Let's get the wording in there. It's any person who claims the disputed chairmanship and is not.
And it's not. Mm-hmm.
Yeah. Okay. Just making sure we're capturing it correctly.
Mr. Rufo?
No, that's not the wording.
Oh, what is it?
Any person who claims the disputed
Oh.
chairmanship and is not recognized, etc. Anyway, I'm not sure if it's the best answer, but let's see what people think about it.
Yeah, I'm gonna highlight this differently. I know this is, don't worry about that little S there. Just trying to make it clear what we're adding, Mr. Rufo.
I think that was an artifact from before. I'm very
Okay.
sorry.
Okay, this then allows the person who won to appeal because they want to humiliate, because they're positive that JC's going to rule in their favor and they want to humiliate their opponent. Or they think, I'm not going to have peace in my state unless I have two bodies making this decision. So it's not any person who oh, maybe it doesn't do that. I don't know what I'm saying right now. Okay, never mind. I was a dumb buddy. I'm fine. I'm fine with it. I was a dummy. Mr. Rufo.
I just off the cuff throwing it out there, not necessarily making an amendment because I know I can't. But what if we said any unrecognized claimant of the disputed chairmanship? Would that not like just throwing it out there for people to think about? Any undisputed claimant of the any unrecognized claimant of the disputed chairmanship.
I like that better.
I think that says exactly what we're trying to say without all of the ands and who's and ises and commas and whatnot.
And then it would just be may appeal. It doesn't even have to say it's not recognized by the Libertarian National Committee, because that's obvious by unrecognized claimant.
Yes.
So that would get rid of, like, let's just, I know I'm getting into million, underline I can't do. Okay,
Sorry for anybody offended by how dirty this quasi amendment is, but
so it would say any unrecognized claimant of the disputed chairmanship but we don't need may appeal. It may appeal to the Judicial Committee. I think that's way cleaner. If Mr. Seebeck agrees it's cleaner, which I don't know if he does, he can withdraw his and I can withdraw mine.
I'm willing to withdraw it, but I also see a major problem with it, which I would like to address a little bit afterwards.
Okay. So is there an objection to both Mr. Seebeck and I withdrawing that hot mess that's up there, and instead we're going to be talking about Mr. Rufo's suggestion? Okay, hearing none, that's what we're doing. So
I think you might have deleted too much.
I did not.
Okay.
Okay, Mr. Seebeck wanted to, since he kindly withdrew his, I would like to recognize Mr. Seebeck first.
Okay, maybe I'm seeing something that's not there. But with this wording, any unrecognized claimant of the chairmanship may appeal to the Judicial Committee. Maybe I'm tired, I'm not sure. But does this, well, no, I'm tired, but I'm not sure if I'm seeing this right. Does that open the door for having 12 different appeals by 12 different people all claiming to be chair of an affiliate to the JC?
If that's the dispute that the LNC decided not to recognize.
That's the case. If I'm on a JC, I'm looking at that going, no.
But it would be that way even with the other wording.
Yeah, I know. That's the problem I thought I was saying.
I mean, it could happen if that's the dispute. We can't dictate what their dispute's going to be.
Maybe that's looking at an extreme absurd case. I don't know. I'm too tired to think straight right now, but I don't know.
Yeah, I think that we can't foreclose that possibility because we can't tell people how to argue. We can't tell people they can't have 20 people claiming. But if it's super frivolous, I think the LNC is going to dispose of it quickly and the JC can dispose of it quickly. I think the example Ms. Matson gave when I can't pronounce the leader of China, which is Xing Ping Pong. I'm sorry, I know that sounded terrible. What's his name? The guy who just came to California.
Winnie the Pooh.
ZZ Ping or something.
ZZ Ping. Yeah, like if he claimed
ZZ Top, I don't know.
Yeah, ZZ Top claims to be the chair of Colorado. Like we can dispose of that right away. I think the people that have like some kind of credible dispute, it's going to get narrowed down to that really quickly. So again, I think this is one of those hypothetical possibilities, but not real ones. Mr. Latham.
I just wonder if our word any there is problematic. And I started to say, how about replacing any with the, but since someone presented the scenario, you might have multiple claimants. How about each? So replace any with each unrecognized claimant.
What does that solve?
Well, I think any has this kind of all comers energy, and anyone who makes a claim. Whereas, because I thought at the beginning we were really only talking about one person, like this is just one person we're talking about, and that's why I suggested the gets us there. But now with this idea that there could be multiple claimants, we could still accommodate multiple claimants with each, and just not have that all comers, all appeals language with any. So
if I may,
Mr. Rufo?
kind of like in a brainstorm, if I may, I think if we did the and then put a parentheses S at the end of claimant, it approaches everything that everyone just talked about. If you said the unrecognized claimant with the S in the parenthesis, this way it allows for more than one, and it's cleaner and it doesn't have that vague any that everybody is. I'm willing to change my amendment right here if I can do that to say the
And I'm-
unrecognized claimant with an S in parentheses of the disputed chairmanship.
And I'm okay with that.
And I'm okay with that. Is everyone else okay with that? We are flying by the seat of our pants. We are getting into Robert heresy territory. So just be careful, because Hahnemann might come and burn us at the stake. I'm just joking, but we really are. But as long as no one's rights are violated. So sorry about that. I'll fix that. Claimants. Well, apostrophe S. I'm good with that. Xi Jinping. Okay, that's it. I'm bad enough with American names. I can't do foreign names. I am the worst. Okay, so the unrecognized claimants of the disputed chairmanship. Mr. Rufo.
I'm sorry, it's still up from before. I'm bad
Okay.
at that.
I'm going to ask, hopefully, is there any objection to this amendment? Yay. Okay. That is now in here. I'm going to ask if there's further amendments to this, and I'm going, I was going to say, choose your words wisely, because I think some committee members are sharpening knives. Mr. Bracco.
If I remember our motion to extend correctly, I would like to call the orders of the day.
I amended the motion to extend to say we were going to finish this no matter how long it took. And I meant the whole proposal. And if someone wanted to call the question to get it over with, we can do that. That's why I was asking if there was further amendments. Mr. Rufo.
Well, I don't want to call the question if there's no further amendments, but I want to call the question.
Well, that's what I'm asking informally. Is there anyone else who wants to amend anything?
Yes, I have my hand up.
Okay. Can you briefly? Yeah. Okay. What is it that you would wish to amend?
It's that it's before affiliates. Change that to the. It's on the fourth line. Because I think it's presumptuous when the LNC is in the middle of trying to ascertain who its affiliate is to say its affiliate. So the affiliate's key leadership. So I think you're still doing, it's consistent with how you're identifying affiliate elsewhere in this proposal. So I don't know why its is there.
And I don't know why key leadership would be there any longer either. Wouldn't it be the affiliate's chair?
Oh yeah. So that would maybe be the identity of the affiliate's chair. That would be my motion. So replace its affiliate's key leadership with the affiliate's chair.
Is there any objection to that? If everyone understands, it's striking its affiliates key leadership, and it used that phraseology because we had all those various offices in there before, and we can simplify this to just say of the affiliates chair. Seeing none, that's in there. Anyone else have any further amendments to this? Hearing none. Because there was some objections before, and I don't know if we convinced those persons, we're going to do a roll call vote. Immediately when that vote is done, we are adjourned till our next meeting in 2 weeks. So, Ms. Arrowwood, what we are voting on is approving this proposal.
I'm going to say yes. Rocco,
Yes.
Sazelsky,
Yes.
Latham,
Yes.
Martin,
Yes.
Moulton,
No.
Rowlett,
Yes.
Rufo,
Yes.
Seebeck.
Oh,
I'm sorry, was that a no, sir?
yes, that is a no.
All right. Madam Chair, at this point, we have 7 yes and 2 no. Do you care to vote?
I thought there was 3 no's and 6 yeses.
No, I have Moulton, no, and Seebeck, no.
How did Mr. Latham vote?
He
I'm
voted
voting,
yes.
I want to give it a chance. I want to give peace a chance.
Oh, so we did convince Mr. Latham. Okay.
Despite my earlier strong objection, I'm willing to give this a chance.
Okay, I'm not voting, because it's not needed. So this passes. Congratulations, we have something. I think it's good, actually, for a messy situation. Next meeting is in 2 weeks. We're gonna start with the interrupting microphone, item. I'm going to post that on the list to try to get whatever. I hate debating on the list, I really do. But maybe we're gonna start, despite how much I so hate it, because I have responditis. But also, if people have amendments of just like little words here and there that are annoying them, please can we do that on the list? So that we have at least that kind of stuff done, or at least suggested. And perhaps, I believe this is Mr. Rolette, if he wants to make that part of what he moves. So I'm going to start that discussion on the list. We are adjourned now. We're going to